Hello and welcome to our today's series and session. Today, I want us to talk about an issue that I know most of us are very familiar with, and an issue that has been mind boggling to a number of us, specifically our audience who, in one way or the other, have had an interaction with the criminal justice system here in Kenya. I'll be handling an issue that I can possibly say is prompted by a discussion we had today in the morning with my wife on an important matter touching on national security. And on this, I will be talking about an issue to do with bond, bail, surety, cash bail, and among many others. But more specifically, I'll be handling an issue with bond and bail. What does it mean? How does it affect you? How does it concern you? What does it mean? How do you go about it? What does it all entail? And so on and so forth. And to begin with, I would want also to make it very clear that a discussion on on bail and bond is primarily an issue that is well handled or well expressed in Article 49(1)(h) of the Constitution of Kenya that speaks about the rights of the arrested person. Among the rights of the arrested person are to be granted bail or to be released on bail or bond. To begin with, I want to say that from the onset, that once you are arrested, having understood all the other provisions of Article 49 on the rights of the arrested person, what then does it entail, or what then do you, an arrested person, qualify for as a right under Article 49 on bail and bond? The Constitution of Kenya, under Article 49(1)(h), as I've mentioned, provides for any arrested person. In fact, the provision is very clear that among the rights that an arrested person must enjoy or should enjoy is the right to be released on bail or bond pending trial. I talk about trial in this case, I mean you've been accused of an offense under the penal code or otherwise, and therefore you must go through the trial for you either to be proven guilty or otherwise. Before that decision is made, then every person has a right to be released on either bail or bond pending that decision through a trial. What it means is that ordinarily your determination of guilt or otherwise must come at the tail end of your criminal proceeding. It means that when you've committed a criminal offense, you are arrested, taken to court, then a procedure follows, a procedure that will determine either you are guilty or not, either you are acquitted or found guilty or sentenced. That procedure takes long, and therefore, before that decision is made by the court following that criminal procedure, then the law allows you to have your case proceed when you are outside. When I talk about outside, meaning you are not remanded or you are not in custody. And what makes you not to be remanded or being in custody is what we are discussing today, that the court may decide to allow you have your case proceed when you are outside or you are not in custody. Then it brings me back to a discussion that we want to understand. A discussion on what then must take place for you to have your matter heard or tried when you are outside or when you are not in custody. That statement then, therefore, invites the two terms that in most cases are either used concurrently, simultaneously or separately. The terms I mean in this case are the terms bail and bond. But before I invite the legal aspect of it, allow me to bring you back to the layman's way, or in an example that will make both of us understand what we mean by those two terms. Assume you are traveling with your friend to Nairobi from Kisumu. Then upon reaching a bus station, you've realized that the fare has hiked, and therefore it's beyond what you budgeted for. Or forget about it. Assume you went to a supermarket, you went to buy an item with your friend. Upon reaching the counter, you realized that whatever you thought is the price for this item that you must buy is not the case. In this case, the price has hiked positively. Assume it was 2,000, now at the counter you realize it is 3,000. But you have your friend here. You ask your friend, hey bro, what do you do this? Would you mind assisting me with 1,000 shillings? I top up here, buy this item, then I'll pay you in 2 weeks. Then your friend, because he's in a position to financially to assist you, he comes in, assists you purchase the property. In the street language, they say your friend decides to bail you out under condition that you will pay him in 2 or 3 weeks, depending on how the agreement is all. That is exactly what bail is all about. That you are allowed, or you are given permission, or you are given a leeway, or you are given an environment to proceed and have your matter tried when you're not in custody. You are bailed out. And how are you bailed out in this case? There is what the court accepts as a condition for you to have your matter heard out of custody. So in this case, the court will say, okay, fine. We allow you to have your matter heard when you are home doing your other businesses, but you must do ABCD. This ABCD I'm talking about are conditions. Conditions may be financial conditions or any other condition that the court may find fit. And then we must now understand why bail, why bond. Once you are arrested and you have a matter that is active in court, the court expects you to be coming to court when it is needed or when it is necessary. So, as an assurance to the court that you will be coming to court when you are needed, then there must be a condition. And this condition in this case will be a bail. Bail in terms of the court is saying, okay, fine. You're saying we'll allow you have your matter heard when you're outside there doing your other businesses, but you must deposit this sum of money as security. You're saying I'll deposit 10,000 shillings. The court says you deposit 10,000 shillings. That 10,000 shillings is an assurance to the court that you'll be coming to court. In some instances, the court may look for something else. You've had people have said the bond of 1,000,000, cash bail of 500,000, and surety of similar amount. What it means in this case is that the court is saying, okay, fine, we are giving you conditions. You've asked that you want to be released and have your matter heard out of custody. Fine, we are asking you, then give us a bond of 1,000,000. A bond in this case is a non-cash or a non-money or non-direct money transaction in this case. We're saying a bond in this case is a security. The same way when you go to borrow a loan from a bank, you tell the bank I would want to build a business premise. I'm in short of 6 million. Or ordinarily, a good example would be you're telling the court, or you're telling your SACCO financier, in this case, telling them, I want to purchase the Mercedes Benz, but I want the bank to finance me. I'm in shortage of about 4 million. Then the bank tells you, fine, we have no problem giving you 4 million, but we need security. Then what is our security in this case? It can either be a title deed of another property, a logbook of another vehicle, or possibly your shares from another circle or otherwise. So the bank will give you money to purchase the Mercedes Benz you intended to buy, but for the safety of the bank, as an assurance to the bank that you'll pay, they ask you for a logbook, a title deed, or otherwise, as I've mentioned earlier. That's exactly what happens also in court. They're saying, fine, we will release you, but we need a bond of 2 million. So in this case, you will either bring a title deed, a logbook, payslip, and so on and so forth, with surety of similar amount. Surety in this sense, surety is a person who also comes in to commit that should Ben fail to come to court, I'll be liable. I'll make sure that Ben comes to court because that is the purpose of bail and bond. I'll make sure that Ben comes to court when and when he's supposed to. And then this surety, who is a person, is saying, as I'm saying this, I am also attaching surety of the same amount. If the amount in the bond on the other side was 1 million, the surety or this person or this guarantor, when we talk about financial institutions, this guarantor comes in and says, I also have a land in Milimani or this Porsche estate or wherever the place would be that is valued at 1 million. Should this guy fails to come to court, then I am liable. Why are you liable as surety? If Ben fails to come to court, number one, you must make sure that you attend court that specific day and explain to court why Ben is not in court. If you are not able to get Ben, of course, the court has a procedure of helping you or of providing you with an environment to make sure that you are able to bring Ben to court. Understanding that apart from you as the surety and the accused or the accused person in this case, now no longer the arrested person, the accused person, the court will give you an opportunity to produce the accused person who has absconded. So what happens? You come to court, tell the court, Ben was supposed to come to court today. Unfortunately, I'm not able to get hold of him, and he is not here. So you're asking the court, I request that you give me a month or so to look for him. Understanding that if you fail to produce Ben, or if Ben fails to come to court and you are there as his surety, you risk being jailed for 6 months. That is number one. Number two, you risk losing the property that you attached as security for the same. So if you, for example, you attached your payslip and in your payslip, if the court said that a bond of 100,000, and the court is able to understand that from your payslip, whatever you are being paid can pay 100,000 shillings, then your employer will be asked to remit your salary to court, and therefore your salary will be forfeited in the sense. If you're able to get Ben, then good for you. The investigating officer, because Ben also has a consequence of not coming to court. If you are released on either bail or bond and you fail to come to court, two things will happen to you. Whatever you attach as your bond or bail, if you paid 50,000 for as a cash bail, or you attached a property that's similar to that, or similar to the bond that was stipulated, both of them will be forfeited. Apart from being forfeited to the court, then the court will also release what we call warrant of arrest. So when you as a guarantor, you as a surety, I'm using both words interchangeably so that we may also be able to understand them from the layman's active. Don't worry about the kalele outside. I'm in my farm. It means that Ben has a warrant of arrest, pending warrant of arrest. The warrant of arrest in this case is a certificate allowing the police officers to arrest you and take you to court. Whatever was attached has been forfeited. You have been able to produce Ben to court, then you are able then to come to court that you're no longer ready to proceed being a guarantor, being a surety to the accused person. And therefore, whatever you attached is released, and you as a person, you are also released from this. Ben will be remanded because the court is sure that when he is remanded, he will be produced in court when needed. So once that is done, it means you have abused your bail and bond terms. in this case, you must continue now uh, having your matter heard and tried when you are in custody. Allow me to take you back to what I discussed earlier. And what I discussed earlier, I was referring to Article 49(1)(h) that clearly says that everybody has a right to be released on bail or bond. This is a departure from the previous constitution. And I talk about the previous constitution, I'm not referring to the 2010 constitution, that did not guarantee that every arrested person or accused person had that right to be released on bail or bond. In fact, prior to 2010 constitution, for you to be released on bail or bond, then you needed to apply for it. You needed to apply for it. And there were other offenses that were categorized as non-bailable. This included treason, robbery with violence, murder, and so forth. Those offenses did not guarantee or provide for bail or bond to the accused person, as opposed to what we are having today under the 2010 Constitution of Kenya. What therefore it means that bail and bond are protected by law. Apart from being provided for in the Constitution, they are also provided for under the National Police Service Standing Orders, Section 7 to be precise, that provides that when you are arrested, for example, you are arrested on Friday, the next court session, because I had read, don't know whether I read or if I didn't read it here, but if you read Article 49, not H in this case, but now if you read Article 49, I think F. If you read Article 49F, it requires that you are supposed to be brought before a court as soon as reasonably possible. And in this case, we're talking about within 24 hours. And there are exceptions that 24 hours may fall outside the ordinary court working days. Maybe the 24 hours is falling after Friday, and therefore then the next court session ordinarily is on a Monday, or the 24 hours is in between a holiday and the courts are not sitting. Then in most cases, then the police are also given a leeway to provide bail, not bond. They may release you on bail if they realize that it's not a heinous act or a capital offense or an offense that if they release you, then you're not able to come to court. So the police may release you, pay police cash bail. They say 10,000, pay 10,000, 50,000, 100,000, then you are released with an assurance that you will come to court. What happens when you come to court? The day you report to court, the police are supposed to release the cash bail that you deposited with them the same day you are appearing to court, because you are now moving from the police station to a court station. And this station, therefore, the court will therefore determine their own terms. And in that case, if let's say you are released on cash bail or police cash bail of 50,000, you need that 50,000. Should the court also release you on the same as cash bail as you proceed to hear your case, and therefore the police are supposed to release that money as soon as you're brought to court. When this has happened, then you will have to move on. As much as Article 49(1)(h) provides for every accused person to be released on bail or bond, the Constitution provides for occasions or for instances when one can be denied either bail or bond. And what are these instances? The Constitution refers to them as compelling reasons as to why you should not be released on bond or bail. There are a number of reasons as to why you may not be released on bond or bail. One of them, for instances that are mentioned where the accused person has failed or absconded court, then the court may, by that decision, fail to grant you bail or bond because there are previous records that you have abused that right. And therefore, the court may be convinced that should you be released, then there are higher possibilities that you may fail to attend court. Another reason as to why the court may consider that as a compelling reason is on the safety of the accused. Look at a case of murder, look at a case of defilement, look at a case of rape, look at a case of robbery with violence, look at a case of terrorism. When the court is also of the opinion, or the court is persuaded by the prosecution that if you are released, in fact, not by the prosecution, by the probation officers, that should you release the accused person, he is likely to undergo danger, or his safety and security is not guaranteed outside, then the court may not release you. The community, in one way or the other, have said, ebu wajaribu kumwacha arudi hapa, meaning your security and safety is not guaranteed if you are released. Then the court may deny you bail or bond. Another compelling reason as to why a court may deny an accused person bail or bond is when there is no commitment that the accused will attend court. Maybe you're a flight risk, you are likely to run away, vanish in the thin air. Then the court may not release you on cash bail. Because what happens if what you need is just to be released, go out, then you will fail to come back to court. Then the court, if convinced, may not grant you bail or bond. Other instances are where the court is convinced that there is a possibility of you either interfering with evidence or witnesses. Then the court may not grant you either bail or bond. And in those instances, if the court is pushed or is persuaded that you deserve to be released on either bail or bond, then they are what we call the bail terms. The bail terms are instances where you've had an accused person being released on either bail or bond with instructions that 1, you should not go to that office, 2, you should not go to that area, like when one of the former governors was arrested in Migori over a murder case. The governor was instructed not to step foot in Migori County or in Homa Bay County. We've heard of recently on the death of Honorable Sir Charles Ongondowere, where among the accused persons were released on bond with terms that he should not go to Homa Bay County. So those are among the many other compelling reasons as to why, as much as Article 49(1)(h) provides that you should be released on bail or bond, but it comes with some other overriding conditions. Therefore, as we understand these terms, we must also understand that when you are released on either bail or bond, you must attend court. There are also another category of persons here that we must also discuss. Persons that are released on personal bond. Let me say personal bond. In a layman's language, or in an alternative language, it is called free bond. These are guys who've committed petty offenses over speeding, creating disturbance. In those instances, the court may allow you or may grant you free bond, meaning you're released without paying anything or committing anything in terms of value or material. But the procedure is different. When you are being given a free bond, then it is pegged on a number of other instances. There must be your chief's report indicating that you are known, your residence is known, your location is known, your workplace is known, and so on and so forth. And therefore, there's a guarantee that you will be attending court. Then when that is also done, there is also another department that is very much key when it comes to matters bail and bond. In fact, you must have heard that so-and-so will have his bail or bond hearing on this specific date. That is a date that the court is supposed to be convinced or otherwise that you require bail or bond. And in most cases, there is a report that comes with it. And this report comes from a department that is known as probation and aftercare services. These are people who will go to the ground, check on whether you seriously deserve that. Are you a first-time offender? Do you have other previous records? What is happening on the ground? Then they must also provide such reports. That should you release Ben on bond, it is okay. Swim and dry, he'll be able to come to court. And he'll be able to adhere to the terms and conditions. Looking at his records back at home, at the village, at the community level, then there's a guy who will definitely come to court. They may also give a contrary opinion that you do not deserve to be released either on bail or bond. And therefore, the court must also take cognizance of such reports and such statements when they are determining or deciding on whether you are supposed to be granted bail or bond. Therefore, as you approach court, know very well that there are also instances, because the law says that you must be released on a reasonable. In fact, allow me to read it verbatimly. Article 49, 1H, because that is where we are today. Of course, I'm not going to refer to what is there on bail and bond policy guideline, which you can also Google and find bail and bond policy guideline that's also available. That a person shall be released on bond or bail on reasonable conditions, pending a charge or trial, unless they are compelling. My concern is on reasonable conditions. Reasonable. You cannot be granted. Actually, you are not supposed to be granted. If the court is convinced that you deserve to be released on either cash bail or bond, it must be reasonable. It must be something that you can afford. It must be something that even if you are stretched, you can try and achieve. Assume a peasant farmer, someone who was arrested for possibly trespassing, or his cow trespassed and went into the neighbor's plantation, destroyed some few crops. Then you're taken to court and you're released on a cash bail of $500,000. You're just a peasant farmer in that grass-thatched or muddy house. Is that bail or bond reasonable? So the court must be able to determine that whatever they are imposing as bail should be reasonable to you. You must be able to pay it. And in instances where you feel like what the court is awarding you, or what the court is imputing, or what the court is recommending, or what the court is ordering as a bail or a bond, you cannot be able to afford, then you have the right as an accused person to raise up your hand, say, Your Honor, I'm sorry, 50,000 that I'm being asked to raise as cash bail, I'm not able to afford. I'm requesting the court to allow me pay 20,000 that I can try and get. Then the court will look at two things: whether you are genuine and the nature of the offense. If it is murder, of course you understand, you can't be released on 20,000. So that's why I was talking about the conditions and the nature of the offense. So the court may review the bond and bail. In some cases, people have been released on cash bail. The court has said, okay, fine, you can have your matter heard outside or when you're not in custody, but you must pay 50,000 as cash bail. The person is not able to raise it. The person is in remand. So anybody who is in remand, the case is supposed to come for mention every 2 weeks. Within those 2 weeks, the court should be able to determine that the cash bail that we imposed on him is unable to, and therefore you're allowed the court at its own motion. The court can have it at its own motion, determine it. Its own motion in a legal term is what called in suo motu. The court may relook at the bail and the bond terms and review them to a level that the accused person is able to afford and is able to have his matter heard outside. So, ladies and gentlemen, allow me to stop at that point, but I'm sure that possibly we are able to understand, if not everything, but at least we are now in a better place to understand what these terms mean when we are in court and when we are asked to adhere by them. Otherwise, I'll keep on posting, I'll keep on engaging you on both legal, political, social, and economical issues as we proceed. Otherwise, I want